Okay, our next session is on the prohibitive grounds of discrimination, and is going to be presented by the UCTE Labor Relation Officers, Colleen Strong and Sean Fields. They'll help clarify what are the grounds of discrimination and explain what makes a prima facie case of discrimination. And they'll probably explain what prima facie means as well. So, Colleen and
That's
Sean.
a lot of pressure.
Yeah, we will. It's in there. Oh, sorry. Well, good morning, everyone. Thank you very much for having us here today. We are going to talk to you about what Chris introduced us as, but it's a very good topic to discuss with you, considering this whole conference has led around equity and some of those issues. So, you know, there was some great discussions that happened over the weekend, and what we want to talk to you about is if you're in a situation like that at work and your rights aren't being addressed, what you can do about it. So we're here to talk to you about defining discrimination.
So before we get into our speech, who's filed a grievance relating to discrimination, personally or for a member?
So just raise your hand. So a few of you.
A couple, good. Not you, Dave, that doesn't count. So who's filed a human rights complaint or assisted a member in doing so? We've covered that. Who's been successful in their discrimination grievance and or complaint? Oh, excellent. Good.
So not a whole lot,
No.
really, when we look at the crowd. So we want to talk to you about today about what are the 13 grounds of prohibited discrimination. We're going to ask you some questions.
And first, we're going to put it to the floor. Can you guys come up with some of the 13? We don't have a mic? Oh, okay.
So I heard age.
Sex.
I heard sex.
Maybe that was just me that
I heard
that.
race. Is there any others? Age, sex, race? Sorry. Put your hands up and I'll point to you. Religious beliefs. At the back. Age is said, yep. Marital status. Denise. Family status.
Yep.
At the back. Criminal record or pardon. Conviction for an offense where a pardon has been granted. Excellent. Over there. Gender identity or expression. Yep.
Perfect.
Political beliefs. So we are not in the political sector. There's a convention for where a pardon has been granted. However, that is not actually in the code. Yourself. Disability. Excellent. Thank you.
There was one over here.
Chris. Creed. So religion or creed, yeah. National or ethnic origin. Is there 1, 2, 3 that we're missing? Genetic makeup. Yep, so your genetic characteristics. We missed a pretty obvious one, so there's
2 actually that are left, but
color. Thank you. And that's it. I think we nailed them all. So
yeah.
Good job.
Excellent.
So what is a discriminatory practice? Let's talk about that in the context of employment. I'm sorry, our slides were not even fast forwarding. Look at me go.
Oh, I thought
Sorry.
they were doing that. I'm sorry.
Yeah, that's okay. Let's go. So there you go. You have your 13 prohibitive grounds. We're going to go through. Sorry about that. So what's a discriminatory practice in the context of employment? So it's a discriminatory practice to directly or indirectly, according to the code, to refuse to employ or continue to employ any individual or in the course of employment to differentiate adversely in relation to an employee on a prohibited ground of discrimination.
So employment applications, advertisements, it is discriminatory in connection with employment or prospective employment to publish or advertise or any advertisement or to make any oral inquiry that expresses or implies limitation, specification, or preference based on a prohibited ground of discrimination.
And what about throughout the organizations? When we look at employee organizations, we look at the discriminatory practices that an employee or organization on a prohibited ground of discrimination. So it's to exclude an individual from full membership in the organization, to expel or suspend a member of the organization, or to limit, segregate, classify, or otherwise act in relation to any individual in a way that would deprive the individual of employment, opportunities, or otherwise adversely affect the status of the individual, where the individual is a member of the organization, or where any of the obligations if the organization pursuant to the collective agreement.
So a discriminatory practice or policy.
Going back. Sorry, hit the wrong button. Go for it.
It is a discriminatory practice for an employer, employee organization, or employer organization to establish or pursue a policy or practice or to enter into agreement affecting recruitment, referral, hiring, promotion, training, apprenticeship, transfer, or any other matter related to employment or prospective employment that deprives or tends to deprive an individual or class of individual of any employment opportunities on a prohibited ground of discrimination.
So when we talk about discrimination, what do you need as individuals in order to establish a case? So when we talk about hitting the grounds of discrimination, you have to have what's called a prima facie case of discrimination. And in that, there are three perspectives or lines that are actually to describe prima facie. So when you want to establish that and show, these are the three things that you need to have. You need to have a characteristic that's protected, the grounds, the 13 grounds that we talked about from discrimination. You need to have experienced an adverse impact, okay? Something that affects you within a social area that's protected by the code. So the things that we just told you about that are in the code in status of employment. And the protected characteristic was a factor in the adverse impact. So that directly affected and had an impact on you as an individual in the context of employment.
So to continue, a claimant must show that discrimination occurred on a balance of probabilities. That it is more reasonable and probable that discrimination did take place. Once a prima facie case has been established, the burden shifts to the respondent, in this case the employer, to justify the conduct. If it can't be justified, discrimination will be found to have occurred.
So we'll talk to you about how to file. What do you do in a case that you feel that you've met those grounds of prima facie discrimination? You've been discriminated against in a context of your employment. What do you do? The avenues are simple. You're going to contact a member of your local executive. You're going to contact your local president. You could contact your RVP. You could contact us. And you would have that conversation, but we would look at the collective agreement. We would take the ground that's in your collective agreement and file a grievance. We would also be looking at what that would consist of. So you're looking at very easy terminology that I grieve the employer breached article such and such, depending on your collective agreement, Treasury Board Article 19, private employers, different articles and different collective agreements. and against my person. One thing that you need to remember about discrimination complaints is you need to identify the ground in which you're basing. So if you go into a grievance hearing and the employer says to you, well, I need you to declare what ground of discrimination are you declaring? Because if you don't declare, the employer will come back and they will tell you discrimination hasn't happened in your case. So it's very important that you do declare that, and there could be several grounds that you're declaring. You could be discriminated against for your age and your sex. You could be discriminated against for your age and your family status, your national or ethnic origin and your family status. I mean, there's several, right? So you gotta make sure that you encompass all. But one of the things that you have to remember is that you can prove or you have the grounds of prima facie in order to establish that case for yourself. The corrective measures, when we talk about that, we talk about the code, the Human Rights Code, and what grounds you're gonna look at, because in discrimination cases, you can claim damages. And that is directly related in the code. So if the fellows at the back would be so kind, just on the link below, when we ask for damages, to click on that, that will actually bring up the code, and I can show you the grounds that you would claim. So in your corrective actions, you would look at Article 53, 2CDE, and 53.3. Is it possible for you guys to bring that up? Well, as we wait,
Yeah.
I will, oh, there we go. Are we getting?
Yep, we're there.
Perfect. So on this side, I'm just gonna go over to the screen. So we've got them both. Well, I can see them in English. Anyway, so 53.2, D, E, and, or sorry, C, D, and E. So Article C says that the person compensate the victim for any or all of the wages that the victim was deprived of, and for any expenses incurred by the victim as a result of the discriminatory practice. D, that the person compensate the victim for any or all additional costs of obtaining alternative goods, services, facilities, or accommodation, and for any expenses incurred by the victim as a result of the discriminatory practice, and that the person compensate the victim by an amount not exceeding $20,000 for any pain and suffering that the victim experienced as a result of the discriminatory practice. In Article 3, the special compensation, this is something that in addition to any other order in this clause, the member or panel may order the person to pay such compensation not exceeding $20,000 to the victim, as the member or panel may determine if the member or panel finds that the person is engaging or has engaged in the discriminatory practice willfully or recklessly. So when you're creating a discrimination case, when you're asking for damages, these are the articles that will be referenced in order for you to be able to reclaim those damages for yourselves. So a very important thing, I would encourage you to look at the code, but it's one of the things that I would recommend for you in order to ensure that you're going to be able to get those damages from your employer.
So filing a human rights complaint. So you can go to the website as shown on the screen.
Can I get the next slide, please? Sorry. Thanks. You can just read it.
We're still on the website. Oh, that is the website there? Okay.
Yeah.
So specific grounds of discrimination must be identified. A detailed description of what happened will be required, stating how you were discriminated against. It will be asked how the discrimination has negatively affected you. The complainant needs to file within 12 months of occurrence. The complainant will be dealt with after all grievance avenues and levels have been exhausted. Now, one thing that we are encouraging, and it's not in the slide, is that when you file your grievance against the employer, that you contact the Human Rights Commission and you file that at the same time or within a week or two. And that way you're covered. They will give you a file number And then when it's exhausted through our particular system, then they'll start using their system, their process. So you've already done that. They'll give you a file number at that time. When we've exhausted our system, then they will take over. You will already have a file number. Okay?
So in front of you, you have the actual site that you would go to for the Canadian Human Rights Commission. And it's a very simple process. When you go there, you'll come up to this page under Human Rights, and you'll go to Complaints. And under the complaint, the specific grounds of discrimination, as Sean has stated, you have to declare that. So under Complaints, I want to complain. And it will actually take you to getting started. It'll tell you what we need to know, what you need to know, and it will allow you to continue through the process to get that complaint filed. So this is something that you could assist a member in doing, or you could get a member to do themselves. And to be perfectly clear, the member doesn't actually have to do it on their own. You could do it for them. I don't encourage that. I would encourage them to go and do it themselves. However, it's not, you don't need to be in the position where it has to be the member that's going to file on their own behalf, okay? So the site is very clear, it's very easy to use, and it's very easy to follow. So if I can just get you back to the slide deck, thank you very much, you guys. The last slide here is when we talk about best practices. My button's not working. So best practices. So to keep detailed notes or a log of events, email yourself. If you have a conversation that involves something that could be a discriminatory practice towards your person, well, send yourself an email. Send yourself a scenario of what happened that day. But it's really important that you document. Documentation can be the game changer in your discrimination grievance. If you receive an email from your manager or something with regards to a situation that happened at work, send it to your home email. Those emails are gold because they're time, date, and stamped in your scenarios, right? So it's very much about documentation and ensuring that you're getting that information to yourself as well. So, and also, if a coworker or there's a witness in your situation, get them to write something down. Get them to send you an email or maybe a synopsis of what happened to you at work. That's a really other easy way for you to prove your case and to assist you in your case. Report any issues to your supervisor. I suggest that you do it via email because, again, your resume of what happened to you that day is time, date, and stamped, and it's bringing it to their attention so that rather they can address it, or you have the situation that you've brought it to their attention and they've done nothing to address it.
So hopefully everyone here today feels more confident in the definition and also the requirements for filing a human rights complaint. Are there any questions? We have a microphone that we can take questions. That'll be helpful.
Yeah, we were the mic people, so we get Mabinti to help us out. Thanks, Mabinti.
Thank you, Mabinti.
Hello.
You're good, sister.
Oh. Am I on? Yeah.
Yeah.
Okay. As someone who's filed a human rights complaint and assisted some members in filing, I understand the grievance process, and then it gets put in abeyance at the Human Rights Tribunal. So how long will they wait?
So you have to exhaust every avenue within the structure before they'll pursue your complaint. And they're going to hope that that gets addressed throughout your grievance, right? So if you file in your grievance, you file to the Human Rights Board, what they will do is they will wait until you've completely exhausted all those avenues before you pursue.
Right, and even if it's 5 years down the road or, yeah.
That's exactly right, yeah.
Thank you.
I sometimes say that's the unfortunate part, but very true.
Okay, I noticed in some of the collective agreements we have, under the discrimination article, it also includes for involvement in my union. But I didn't see that on the prohibitive grounds listed under the Canadian Human Rights Act.
That's correct.
So do we handle that a little differently?
Yes, we do, and it's a great point. So with discrimination, in some of the collective agreements, it talks about membership or activity within the union, right? So thank you, Chris, for bringing that up. But that situation isn't covered under filing for a human rights complaint. That's a completely different process where we get into a thing called an unfair labor practice against the employer. So it's still considered discrimination, but in a different sense, and that would bring you to a completely different process. We've gotten a lot of questions actually about that in the past, or myself that I have, and they say, well, I go to file, but that's not a ground there. It's in my collective agreement, so how do I do that? So again, as I say, unfair labor practice to actually expose that, and that's something that you'd really want to have a discussion with your local executive or your RVP or national office.
Hello? Okay. When it comes to filing the grievance within a 25-day limit, if it's not filed for these types of grievances within the 25 days, does an arbitrator or adjudicator have the authority to overrule that, to accept it?
So do you want me to take it, or do you want to take it?
No, that's a good question. Case law is case law, and what they'll rely on is what the previous case law has dictated. So right now, what they're using is the Collier case, in which you only have the 25 days. You might be able to get them to reverse that, but I haven't seen it happen.
Again, though, you do have a year to file to the Human Rights Tribunal, right? So you have a year to file if you're in a situation where you haven't had the opportunity to file a grievance. You could have that discussion with somebody at the Canadian Human Rights Commission, because you do have 12 months to file a human rights complaint. So there is some leeway that way. However, we do know within the timelines of the collective agreement how that works. But they might be able to give you some assistance that way as well.
Mm-hmm.
Any other questions?
Hello? You hear me? Perfect.
Yep.
I think this is just like an overall statement from at least my level, a CR4. I'm fortunate that I'm now indeterminate. However, I've heard horror stories. Being new, I feel like this was a fantastic presentation. How can we as new employees find this information more accessible, more in our face, so we are feeling empowered, so that people actually know what kind of measures to take, how to feel confident, how to feel empowered, when we have to search through a lot of things and everything's misconstrued after. And then of course, being considered a whistleblower, if you say something, a lot of voices are not heard. And an overall statement is being able to have this information provided more clearly and more upfront through mentorship, I think can also provide more people like me to join a union like this as well. So just as feedback to you. Right,
and for myself, I would tell you that it's something that is a little difficult to comprehend. You know, I always remember when I started back in kind of a union environment that it was brought to our attention about human rights, and they would say things about the fact that if you were feeling these issues in the workplace, that you should file a grievance and file this human rights complaint. And everybody's like, what? What is that, right? But really, it's about looking at the articles in your collective agreement, getting your members to understand that they are part of that collective agreement, showing them, you know, Article 19, because you're a CR4, I go to Treasury Board, and talking about the fact that that discrimination clause does exist. And you know, this slide deck that we did today, you will have a copy of that, but to understand that that Canadian Human Rights Commission does exist, and your ability to actually file those complaints. So again, going back to the local environment and your regional vice presidents that way, they would be able to assist you to show your members how to do that. I understand the part of whistleblowing, but in some ways I look at it and say, well, you have the ability. I mean, would you rather the behavior continue, or would you rather that there's an ability to try and get it to cease, right? Because ultimately, at the end of the day, you want to work in an environment where you're accepted, where you feel welcomed. I mean, I don't think you would want to go to work every day with those practices continuing. And I should also mention too, when you do file a human rights complaint, the employer is made aware. So they get a flag. And for some employers, that's enough to trigger the thought process that maybe I should cease or take a look, take a step back and look at myself and say to myself, what are we actually doing within our department to ensure that those things aren't happening? So it does assist that way as well.
One other thing I noticed, and what I encourage members to do when they're filing a discrimination grievance and a human rights complaint, is we also have the new legislation on violence protection, right? And that also covers discrimination. So that legislation is meant to change the workplace, to identify systemic problems in the workplace, to come up with training, to come up with other initiatives that these things don't continue to happen. And every notice of occurrence has to be tracked and has to be kept on file for 10 years. So I'd also encourage filing a notice of occurrence. Part of the whistleblower protection, I think, will come out of that, because it is, in the legislation, retaliation for filing a notice of occurrence is harassment, and that would precipitate another notice of occurrence. So that, there are more than 2 ways. I guess there's 3 ways to go about it. And so communicate with your local executive, with your RVP, so you can navigate those 3, pretty challenging processes.
Yeah, I'd like to add to that, and nobody is alone when it comes to this. You have your vice president, your local president, your chief shop steward, you have your RVP, whoever that may be, whatever region you're from. We're all here to help you with this process, or any process that you feel is necessary. So don't feel alone. We're here to help.
And just to comment on Chris's point as well, in the workplace violence and harassment policies and in that investigation process, as you stated, it's all about prevention. So how is the employer going to cease that behavior from happening again? However, what it doesn't do is it doesn't address damages. It doesn't address the actual concerns, but you're very right. What it will do is it will allow the employer to put those preventative measures and steps in place for future. It doesn't address the past, it just addresses the future.
Test it. There we go. I want to make sure I don't screw this up. What advice would you give to representatives, and especially new representatives who are approached by members, as far as an ongoing systemic harassment or discrimination? And I don't know about the private sector collective agreements or some of the agencies. The Treasury Board ones have sexual harassment, and then they have discrimination. And we often find that the employers will deem what we file, it's not discrimination, then you try the harassment, but well, it's not sexual harassment. So what's the best way to approach the members as representatives in terms of where to file when it's not even just a single incident? Because sometimes it builds up over time. So your 25 days can be a bit of an issue as well. Thanks.
So I would always say to you, because it happens a lot, it happens to the point that members get to the point where I can't take this anymore. This has been going on for a year, 2 years, whatever the case may be, and I'm done. So take that last incident that the incident occurred, that is your date of filing. You can address the items from the past. You can bring them forward when you're creating that case with the Canadian Human Rights Commission, when you're writing up what you faced. That's why I talk about taking notes. Even if you think You know, even if you have that idea in your head that, you know what, this incident happened this day, I'm going to jot that down with the date and kind of an incident, but I'm not ready to file yet. But you have a log and you have a general idea of what you've incurred in the workplace. But when you get to that point, of saying enough is enough, I'm going to stick my heels in, I'm going to file a grievance, and I'm going to go off the last incident that happened, you can provide all of the backstory and those scenarios to actually form your complaint. So does that answer your question, sister? Great.
But again, what we encourage, and we talked about yesterday in our little session, document, document, document. Because when you, even if it goes back 4 years, when you sit in front of the employer and you have a document this thick with all the different things that they've done wrong, it has a huge impact on the employer. When they come to a grievance procedure or proceeding, they don't have 2 pieces of paper. They come in with like a binder of information against our employees for whatever reason. So if we have that document, 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 we can bring up everything that happened in the past, but it was determined at this point that the person was going to complain or file a complaint or a grievance. It makes it much easier for us to prove.
I have a question too. Geneviève from Local 7710. What happened when in terms of discrimination, it's against the motive of disability, including mental health, and at one point that person is, okay, I'm done with it, but also needs to go on leave to get better and get treatment or whatever else? What about the timeline? Because the 25 days start when the employees say, okay, I'm done with it, this is the last event, but they're also not there to process the file. So how do we deal with those kind of deadlines that also occur?
So I would say a couple different things. You can always file, and we said this in our sessions yesterday, you can always file a grievance. You can place it in abeyance, right? While you're going through whatever it is, if you need to take leave from the workplace or anything else to protect your timelines, right? So that's a mechanism that I would really encourage in that scenario, is to allow the griever to grieve. They have 12 months to put in their human rights complaint, but you're going to protect your timelines by filing that grievance. If you're in a scenario where the member goes on leave and hasn't filed, then there's also the period of still being able to address the human rights complaint. You can try to file a grievance. However, we got to ensure that we try to protect those timelines, as we talked to you in our sessions yesterday. It is important. If you have an argument as to why you were unable to file that grievance, let's say you were very, very ill, those things will all be factors and mechanisms into when you're having that discussion in your hearings. However, I would always tell the members, if you knew that a member was leaving the workplace because of mental health issues, because of a disability that maybe the employer isn't accommodating, there's a lot of different grounds that would go into that grievance. We're not just looking at a human rights complaint. We're looking at, lack of accommodation, et cetera, et cetera. Can go on and go on. However, I would just say to try and protect those timelines. It is important, and it can sit in abeyance while they go through their period of leave to try and get healthy. Yeah. Does that answer your question? Perfect. Great.
Anybody else? No. Lovely. Okay. Well, thank you very much. I do appreciate your time.
Thank you.